My name is Jenise Jackson. I am an estate planning and probate attorney. I'm currently in Houston. I'm from Dallas, born and raised, Oak Cliff, Texas. I got generations. It don't get no more Dallas than me. Um, Dallas high schools. I'm a product of Dallas public school system. Like I said, I went to Baylor. I was a couple of years behind Ben. Um, and after leaving Baylor, I came back to Dallas, did IT for a few years, and then decided to go to law school. Ben talks about, I mean, the praise should go to him. I mean, I look at Ben and I'm like, this is what it can be, right? I've sat in on these calls with you guys only because I'm learning how to be a business owner. So I have my own practice. And so as I sit in these calls, even though there's a difference between what we do, there's a lot of overlap. And so I've been on several of these calls. And so I'm honored that, Ben is letting me speak today. Um, and he's blushing, but Ben knows he is the man. Thank you again, you guys, for having me. So I want to kind of dive in. I think we only have like what, 20 minutes?
Yeah, 25 minutes.
Okay.
Absolutely. We
So
hit.
So, fun fact, I was sitting in a real estate class actually at Northlake when I decided to go to law school. I had always wanted to go as a kid, always thought, oh, I was going to be a lawyer. I got to Baylor, started doing IT, and loved being on the computer side and thought, oh, well, one day I'll get together and I'll do this technology law. Like I had this big dream. And once I started, life, right? Life starts happening, bills start getting paid, and who wants to go back to school and do it all over again? So after, oh my goodness, my age is going to start coming out in some of these numbers. After about 15 years or so in IT, I wanted to change. My company was downsizing and outsourcing, and I started taking real estate classes. Like, well, let's do this. And what I realized that I enjoyed the most about the real estate was the law. I was like, okay, this must be it. This is my calling. I might as well just, bite the bullet. Packed up everything, my dog, put it in a Honda Accord and drove all the way to Georgia, and then went to law school full time at Georgia State. And so now here I am practicing a different variation of property, but all the same. So, as I said, I've sat in on a couple of these calls. And so when I was trying to figure out what I wanted to talk about, the calls talk about, listening to these stellar agents and brokers and all the things that they're doing about growing their businesses and, how they've, have these $1 million clients and like, oh, well, they need to talk to an estate planner. So I'm going to put on my estate planner hat and talk about, what you guys should be doing about planning. And it's not just about having a will, but protecting your family and protecting yourself. And estate planning is not about you. And so I had this, thing in mind when I have my regular conversations with people about what I wanted to talk about. And then I realized these calls are about us, and I use us, the broad us, as business owners. And so I wanted to have a deeper conversation. So instead, I wanted to talk about where real estate and probate law kind of intersect, right? Because we kind of work with the same clients. And so I wanted to talk about how that impacts us and how it impacts our clients and the things that I see as somebody on the other side of that. So,
And that's
how I
why I'm
want
so excited to have you because I'm like, there is an intersection between the two. And I think as professionals, we need to understand that so we can articulate that and the importance of it to our clients. So
right.
you're bringing the meat today. That's exactly what I wanted. Let's go.
Good, good. So, how I want to do that, talk about some of those areas first, right? So, we see it in airships where we're having to deal with who the legal heirs are of a property when you're ready to sell it, distributions, right? We're looking at title, who can take what parts, and then getting into administrations, right? So, I figured the best way to do this was to use stories, right? I like storytelling because, I mean, let's face it, the clients and the matters and the things that I work on are fascinating, right? It's like Dateline for estate planning and probate. Oh, this family thought they were going to get this, and this is what happens. So I'm going to talk to you from a perspective of my client. And I use air quotes because it's not a specific client, but a combination of people that I've worked with or friends who I know have worked with these people or family or, all the different variations. So this isn't one particular person. And I want to present it in kind of like a choose your adventure scenario. Do you guys remember that? back from like when you were kids, right? You kind of pick which section to read in the book and where it goes. So we're going to kind of go down that path. So here are the clients. The clients are Ron and Ruby. They're a gray marriage, which means they married late in life. Over 50 is the definition. They have a big blended family, right? He has kids and she has kids. And so they entered into this marriage with their own separate property. And then some, as they've been married, they have community property, right? We're a community property state. So the day they got married, everything they earned, everything they bought, if they didn't decide to segregate it, was community property. So we worked together, put wills together that reflected their wishes. Their separate property, they wanted to go to their kids. Their community property, they wanted to go to each other, right? Their surviving spouse. So fast forward, Ruby passes away. And a few months later, I reach out to Ron and we talk about administering her estate. So here's where the adventure comes in. Option one, Ron takes the will, he probates it, and you get letters testamentary, right? That's a clean probate. You got somebody in charge of the estate. That's the person who's coming to you guys and said, hey, I'm the executor. I can sign for anything for this estate. I want to get this property distributed. Clean and easy, right? Ron's gone through the probate process. He has had the will proved up and it's a valid will. The court has said yes, blesses them with letters, go on about your business. Easy, best option. Option B, I give Ron a call and he's not ready. Not ready to talk about Ruby's estate and wants to wait. He ghosts me, basically, right? And I don't hear from him for about 4.5 years. He's decided that can't stay in the house any longer. I'm ready to sell the property. And, you did this will for us. Now, how do we go about it? Well, in Texas, you have 4 years after someone's passing to probate a will. So if they come to you 4 years and one day after, there's some challenges. You can get what's called a muniment of title, and I know you guys are familiar with that. But in order to get an administrator, you pretty much have to prove to the court that you have a valid reason for not probating the will. I have it and I didn't think I needed to is not a valid reason. Courts don't like that. It bogs their courts up. It causes lots of problem. Heirs could have changed, assets have changed, right? So we want people to come in and get things done. So that makes it difficult for you guys, right? You're ready to sell. This person has said, we have a will and it says that I'm the executor, and you go talk to them and it's like, well, this will hasn't even been probated. An unprobated will won't get you anything. So Ron's problem is he hasn't done a probate. If we can convince the court to accept the will, we might be able to get an administrator. Without an administrator, we have to go through extra steps, which causes time and money, right? And delays your sale. So we're looking to see if we can get heirs to agree. In Ron's case, he has kids, mom had kids. Maybe they didn't like the will. Maybe they didn't want mom's half going to Ron. So now they're going to make it difficult to probate. So that's what happens in that situation. Let's go back to the beginning. I call Ron. So our next thing in this choose your adventure is Ron decides to keep the house, but he has no debts. They took care of everything else that they were supposed to. They got beneficiaries on their bank accounts. They got brokerage accounts. They have payable on death. They got everything cleaned up, and all that remains is some real estate. They got, some land over in East Texas because everybody has land in East Texas, and they have the house. So he can do what's called a muniment of title. It's a simple probate process. It's not as complicated as the administration. You don't have as many things that you need to take care of. You just go to the court, and what it does is establishes evidence of Ron's ownership with the will. It says, here's this will. We put this thing in place. It goes into the records. And so a title company can see, here were the owners, and now here's the owner, right? And that's it. It only works if there are no debts other than something secured by a lien, right? Like the house. If you have a lot of medical bills left over, or the funeral home hasn't been paid, or right before Ruby died, she decided that she needed $15,000 worth of new shoes, and you're not paying that, right? So you have this debt left over. You can't do a muniment of title. It won't work in that case. A court won't approve it because you have to testify that there are no debts. So a muniment closes that gap in the title. The will gets probated as a muniment of title, goes on the record. Ron's good, right? And he comes to you whenever to say he wants to sell the house. You have no issues. It's clear and you can move forward. No problems with the title. With immuniment, the only issue is that it doesn't address heirs or creditors. Maybe somebody has a challenge because no one's been appointed actually to take care of the state, right? It is what it says. It's a title document. But that's not your problem, right? If you get the house sold and you get him money and the heirs want to come back and argue about that, that's Ron's problem to deal with the kids. As far as selling the house, you have clear title. Option C, Ron wants to sell a house with an affidavit of heirship, which is different than heirship determination. So the difference right off the bat is that an heirship determination is a court order from a judge. You've gone before a judge and testified and had other people testify that these are the true heirs. An affidavit of heirship, we've all seen, is that somebody that the applicant finds comes and says, yep, I looked at this, I agree, these are all the kids, and we'll sign this and file this. An affidavit of heirship does not transfer title. Okay, I'm going to say that again because people get it confused. An affidavit of heirship does not transfer title. It does not fill a gap in the title like your muniment of title will, or like a probated will does. What it does is give the title company some comfort that you said these were the heirs. We believe you that you said these are heirs. If you want to sell the house, we'll distribute to these heirs. That's it. It does nothing else. So if something were to come up, let's say Ron filled out the affidavit of heirship and doesn't really like Ruby's oldest. Didn't want her to have anything, gonna leave her out. She only had one kid. And somebody goes along with that, right? And you file it. Well, they can still come back and challenge that. Any undisclosed heirs can challenge an affidavit of heirship because all it is a statement of facts. It's a statement that we had these kids. Now, in Ron's situation, the reason why it's going to be a challenge for him to have an affidavit of heirship is because they had a blended family. And affidavits of heirship follow the intestacy laws. In Texas, if you have children that aren't also the other spouse's children, your community property goes to those kids. So Ruby's half, let's say Ron and Ruby built this beautiful dream house that Ben Baker sold them. And and with the will, her half would go to him. That's what she wanted, the house to be directly to him. Without the will, if they do an affidavit of heirship, it shows that her heirs are her husband and her children. And now her half of that beautiful home goes to her kids. So an affidavit of heirship may or may not allow you to shore up the estate the way the will does, right? So because it's only showing you the heirs, and the title company would go, yep, these are the heirs, and so we'll distribute it to these people. It won't give Ron his half of the house. So that's why you have to be very careful with them. If they mirror the way the estate would be distributed, no issue. If they start contradicting the will, you got to make sure that person inheriting is okay with that. And they're willing, knowing that they may be giving up something in the will that they're no longer getting. So that's option C. Ron wants to sell the house. He uses an affidavit of heirship. He doesn't call me first. I found out later. Hey, yeah, so I know you said that the house was supposed to come to you, but that's not where we ended up. And so that causes problems in probate. Option D, Ron passes away without probating Ruby's will. So now you have two estates, right? Ron has a will, Ruby has a will, nobody's done anything. And so now which child is responsible, right? If the will gave enough time, there's a time limit that we try to put in our wills that if one person passes within 30, 60, 90 days, that person is deemed to have predeceased. So luckily or unluckily, Ruby passed away first. Their time had passed, and now Ron has passed away. So whose will gets probated? Who's going to be responsible? Does Ruby's will put, her child in control of her half, and Ron's puts his in control of his half? They now need to work together. We have a double probate, right? And what typically happens when people run into challenging situations, they stop, right? Don't worry about it. Not going to do it at all. we'll be fine. We can continue to share the house, is what ends up happening until you have generations of heirs who start to pass away, and that one person gets stuck paying the taxes on a house that they don't live in. Right? I know we've had those situations where you have these challenges with airships, and that's where they come from, right? Either you have a will and you do nothing, or you don't have a will and you do nothing. And the family figures, oh, well, we're able to do all these things, so we'll just keep moving on. The challenges come when you're trying to sell property or you're trying to get into a bank account. Right now, you're trying to figure out how do we go back and change the hands of time because we didn't put things in place, or the things we put in place we didn't follow through with. So in those situations, you end up with disputes between the heirs, Ruby's heirs versus Ron's heirs. We can't get them to agree. Well, it's half mine. What about the separate property? Um, Ron was entitled to a percentage of her separate property because they were married. Do those kids want to fight over that? There's a life estate. I mean, there are all these different things you have to look at, and you have to look at them for every person when you get into airships. You can't just say, oh, well, I'm the last one. I'm paying the taxes, so I want it. Well, there's somebody in that's also where there's always another relative. You got land in East Texas and a relative in California. That's how it goes. There's a relative in California who is your second cousin, once removed, who doesn't want to sell their 1/16th of the property, even though they've never paid a dime toward taxes. So that prevents the agents. Uh-oh, I'm seeing I'm having connection problems. Hold on a second.
I know. I see you. You
Okay.
good? Yeah, you're good.
Okay. That prevents you guys as agents from being able to sell property because now there's some clout on it and you're ready to go. And the title company is saying, oh, I found 5 different people who have some type of ownership in that. Texas has put in some things that make it a little easier to deal with airship properties, but it requires a court case. And if you thought probate court took a long time, district court is even longer. I'm going to sidebar real quick. I have a client now, and we're looking at another year or two before we even get to argue her case. Right. And so she's ready to sell. I got an agent. It's like, well, I hope they have other things to do because this is not going to be quick. But this is where you end up with option D, right? Where Ron passes away, nobody did anything, and now we're dealing with both Ron and Ruby's estates. Okay. So those are very high level options that come, but that's kind of where we end up when we look at the different things that can happen from when people are getting their estates managed and they come to you guys, right? They're like, hey, I'm ready to sell, and here's where I am. So what I would like to leave with you guys as a key takeaway as real estate professionals is first start clearing those legal roadblocks, right? When you're working with people, identify those potential title or ownership issues early and ask all the questions because everybody thinks they own everything. Oh yeah, I own it. Do you own it? That's always my first question. What makes you think you own it? Like, is your name on the deed? Did somebody give you something? And what document did they leave to tell you that it was yours? Grandma telling you at Thanksgiving that she's going to leave you a house that she doesn't even own herself or that she owns with her 6 siblings does not give you the house. Oh, well, I've been paying taxes on it. And my name's on CAD. That's always my favorite. Well, my name's on CAD, so that means it's mine. No, that means you're responsible for the taxes, right? You have tax ownership versus title ownership. And so that's one of the things that as real estate professionals, we on the other side, whether it be a real estate attorney or a probate attorney, like start with those questions so that when we start talking, we don't find out later that, you're ready to close and these people don't own it, right? So that's the first thing. Be proactive with those questions. Ask them first. I hate to say this, but I don't want to say clients lie, but they do leave out bits of information. And when I do consultations, I let clients know, I was like, hey, you need to be as comfortable with me as you are with your doctor. And so any professional that they're working with, especially with you guys doing sales and having to look at finances, you want them to be comfortable because we need them to tell us everything. Right? We need to know everything that has to do with this estate. Oh, well, yeah, I know my sister owns part of it, but I've been doing everything. Or Yeah, I own part of a house, but I haven't done anything with it. I know my sister is responsible for it, so I let her manage it. Right. So those are the things we need to pull out from them. Those are the things you need to know because you don't want to get to that last hurdle and find out that there are actually five more behind it. So ask the sellers about property ownership, ask them about liens, ask them about heirs, right? Who do you think might also own some of this? How did you, goes back to the legal roadblocks. How did you get this property? How did that person get the property? How do you know that you got it, right? Like all those things. Start with the deed, start with liens, start with property records, and flag red flags, right? So just like with dating, you talk about the red flags. These clients that we deal with, we're dating them, right? And so sometimes you're hearing about things, and if your ears perk up, you should kind of dig a little deeper because what you don't want to happen is having to deal with a dependent administration, right? And so a dependent administration, if you're unfamiliar, is where everything that you have to do, the client has to do, has to get approved by the court. Those are not our favorite. Lawyers don't like them either, but you have to deal with everything. I need to get an appraisal done before I put this on the market. Okay, let me go ask the court if I can use this appraiser. Okay, well, the appraiser's been good. It's going to be $600. Okay, let me ask the court if I can spend $600. All right, the appraiser's been done. The report's been done. We're going to put the house on the market. Hold on a second. Let me make sure the court's okay with me selling it. Okay, well, this is the value that we got on the sale. Are you ready to sign the contract? Can't sign yet. Let me make sure the sale is fair based off of the appraisal report before the court before we can move forward. That is a nightmare in courts like Dallas. Big cities where everything has to go through a probate court before it can get approved. Dependent administrations wreak havoc in everybody's lives. So when you start sensing that there's a red flag, always dig deeper. Send them back if you have to, right? It's like, nope, you're not ready yet. Or send them to an attorney. It's like, you're still not ready. Get all of that handled and then come back. And then I think we all know this because like I said, I've been on these calls. We're advocates for our clients. We're not just salespeople. We're not just lawyers. We're advocates. And so we want to encourage them to keep proper documentation, keep things organized, know where things are, tell people where things are. If you're dealing with somebody who's wrapped up in a state and they got all their ducks in a row, great. That's not the end of it, right? You want your family to be able to pick up that same stack of documents and carry on, right? So don't fold it up and put it in the back of a drawer and in the freezer. Had wheels and freezers, where nobody can find it or nobody knows what's happening in your estate, right? You don't have to hand them a copy, but people need to know where to find things. And so if you're going to be looking for it, at least leave something that makes sense, not where you're piecing together, well, it looks like they sold it. Nope. Nope. Here's another piece of paper that says they canceled the sale, right? So those things need to be put together. And then remember your role as a resource. This whole real estate world, we're all working together, right? So we all play our different part. I don't think that anybody's role is any bigger than the other. I can't get my clients to where they need to be if they don't have an agent. And that's one of the things like, hey, I'm ready to sell the property. Great. You got an agent? Because I'm not doing that. Right? I'm like that. I don't want to be involved in that part. There are people who do this day in and day out, and they have the relationships with the title companies, and they have the relationships with the banks, and they have the relationships that get you where you need to be. But I'm going to help clear that for you so that you can work with them, right? So we all work together. So those are the biggest things that I want you guys to take away from what we build together and the different scenarios and how those things work. All right, I think I'm done.
You're good. And Jenise,
Good.
speak to briefly, because Christy and a couple others are asking, they're mentioning trust. So how can we advise, what does that world look like for us dealing with trust or
Dealing with
trust?
trust, it kind of depends on how they're set up. Trust are a good word and a bad word. What I typically do for trust is try to figure out three things, right? Now we're kind of getting into the planning side. Three things that I look at when I talk about trust: people, assets, and the priorities. So the first thing I start with is your assets. Is the land that you own? Where are the bank accounts? So for trust, what we typically try to do is keep people from having to probate all over the place, right? Because what you want is if you got some land in East Texas, nobody wants to go out to East Texas and sit in court because they don't have statutory probate court. So you're sitting behind dog biting cases, the guy who's up for drunk driving, a child adoption, anything else, right? While you're trying to get this taken care of. So we put land in trust to assist with management, right? So if you have one, and kind of all over because trust is a really big topic for like 4 minutes. But if you have one that's part of your will, it's a testamentary trust, which means when that person passes away, that will pours into a trust. So that can't be managed until the person dies, right? It's testamentary, meaning it does not exist until that will has been probated. Standalone, which is what most people are familiar with, living trust, revocable living trust, all those different things, right, are managed with during a person's lifetime. So you're putting the property into a trust and they're responsible for it during the lifetime. So the trust can be set up to also manage the property. The biggest, my best example for a standalone trust is a pickup truck. We're in Texas. And so look at it as everything that you own, you're putting in the bed of the truck. You're driving that truck as the trustee. You're driving the truck and you're managing the stuff in the truck until you're either incapacitated or you pass away. The stuff never leaves the back of the truck if you don't take it out. You got to put it in, got to fund the trust. But if you don't take it out, it stays in the trust. So while you're driving along, you get out, you get hit by a car, somebody pushes you over into the passenger side. The successor trustee is now responsible for managing your stuff in the trust the way you want it to be managed, right? Because you put all these terms and conditions into your trust and how it should be taken care of. When you pass away, push you out the truck, the person who's now driving is responsible for following the terms in the trust, how you wanted them to be distributed. Maybe you wanted the house to go to your kids. Comes out the trust, it gets distributed from the trust to the kids. Now they own it, right? Or maybe you wanted the house to stay in the trust, but you wanted them to rent it, right? So those are the guidelines that you put into the trust. But the trust is the vehicle. And you don't have to go through probate unless it's testamentary, right? Unless it's part of the will, because it doesn't exist yet. But if you have a standalone, that's where the management comes in. For you guys, it really depends on the trustee and the provisions of the trust. You can your role in dealing with somebody who has a trust is only as great or as small as what they've put into the trust. And if it's limited, the law picks up where they leave off. But there are a lot of guidelines around trust. A lot of people, what I've seen, depending on the trust, it's a word, right? And people don't really follow what it means. And so it sounds good until you've passed away and you have somebody who's like, all that's in here is $20,000 and this trust. I don't want to do this. Neither does a bank. Neither does a corporate trustee. So what they need to be doing is trying to figure out how to get the things out of the trust based on the stipulations that were put in the trust. So if you ever see one, the first thing you should do is read it. Don't go with, oh, well, I know it should be doing this. Read the terms, make sure that you're abiding by it because the trustee is a fiduciary, right? And is responsible for the things in the trust for the beneficiary. So they can be sued by the beneficiary. Hey, you're supposed to give me $5,000 a year for school and keep the house in the trust. What happened to my $5,000 a year? Or I mean, you've seen all the TV shows, right? Where it's like, oh, the trustee spent $1 million out of the trust. Yeah, well, you're going to get sued. That wasn't your money, right? So the trust controls that. I think I saw another question. What else? I hope that answered it. It's a really broad question. I promise to invite you to my next thing and I talk more deeply about trust.
I cannot wait to join in on that. I can tell you, this has been so educational, and I know that's what you're about. You love educating people, and I think it also shows the need of relationships, right?
Yeah.
We need you as a partner in this, and there are a number of folks here that are not even in Texas. And I will tell you that, Jenise, you and I, like I told you, we need to get together because again, you can't consume all this in the 30 minutes that we've been here,
Right.
right? So reach out to your partner. And again, I need more education from you. And so I'm ready when you are. You get to Dallas, and we're going to meet and get some of this stuff taken care of because my financial house isn't in order like it should be. And this just enlightens us all. So I hope that most of you guys on today have gotten a little something, or if nothing else, just the importance of educating our clients, right? Period. There it is. So thank you for
Exactly.
dropping the wisdom nuggets on us today and the importance of what it is you do and the relationships that you and I should be in together. So sick 'em bears, my goodness, right? Right. So boom, you've got 2 minutes. Anything else you want to leave with us? Or
I
we
do. I saw somebody pop something in. I think it was Christy about avoiding a trust, avoiding probate. A trust can avoid probate if the client does everything they need to do and continue to do it throughout their life. It makes no difference to avoid probate if you either don't fund the trust, because then you have to go through probate to get the assets into the trust, or you stop. It's not a one-time thing. As you acquire assets, you have to keep putting things into the back of the truck.